Okay, welcome everybody to the Wednesday night VSOF Open Roundtable. Tonight I'm going to talk a little bit about what happens or what you need to do after you exit the system by doing the Vocational Science Freedom doc set, and then we'll just open the floor up to anybody that has any questions about anything and or anything else you want to talk about. If you would like to join the Vocational Science Freedom Gilded server and join in our chats, you may do so either by finding the Vocational Science of Freedom YouTube page and clicking on the Join the Vocational Science of Freedom Gilded server here on the banner. And then you'll be prompted to come on to the Gilded server, and you can either use Gilded through a web page, or I would suggest downloading the client and then joining our online community. With that, I'm going to open up and talk a little bit about the doc set and what the systematic parts of it are regarding what we're doing before and after we end up removing ourselves from the system. And what I was just going to do is just kind of open up the checklist, which is the list of all the documents that we do at the Vocational Science Freedom, and kind of go through why each one of them is a necessity and why each one of them is separate, and the reason of what they accomplish, I guess is the best way to put that. So the first document is the Declaration, Establishment, and Publication of the House Seal. So of course you have to get your seal made, which is a process that we have a handbill for that's in the mega folder, which I will give a link to and put up into chat, even though this is a link that's readily available on the Vocational Science Freedom Discord server. It will cover all of the handbills that you can find to learn about what the process is and how to use the documents. So all of that's contained in that folder. And of course, if anyone has any questions, feel free to contact me on Gilded and just ask me a question and I will answer it as soon as I am available. So with that, open this back up and we can go through these. So, and at any point in time, if anybody has any questions, feel free to obviously put them in the chat if you want as well. So, seal. Why do you need your house seal? Long time ago, I came across, in reading the Illinois State Constitution, the first one, the 1818 Illinois State Constitution. And in the state constitution, in what was called, it's called the schedule. And basically what it is the writing down of what they plan to do to implement this thing, right? Called a constitution. So we scroll down here and we get to the schedule. Okay, now in the schedule, it starts out that no inconveniences may arise from the change of a territorial to a permanent state government. It is declared by the convention that all rights, suits, actions, prosecutions, claims, and contracts, both as it respects individuals and bodies corporate, shall continue as if no change had taken place in this government in virtue of the laws now in force. Now, I'm going to pause there for a minute because I have another point. There's another point to be made regarding that. So at that time, 1818, people had already established this nation as a constitutional republic. All the rights that they had at that time were all based on their own sovereignty, because we took our sovereignty from King George, and we decided to set up a constitutional republic in which all of us remained sovereign and created a government of which was by and for the people and which was subject to our law. And in that, you can see the progression all the way from literally the Magna Carta in 1215 AD all the way to this Illinois Constitution, and now currently, even though most people are not aware of what their rights are. And to make a not too fine a point on it, the only thing you can do with the right is exercise it. Rights protect no one on their own. You have to know what your rights are, and you have to know how to be able to exercise them correctly. In court, out of court, in contracts, and every other aspect of your existence. So with that, to get back to the seal. Now, in 1818, everybody had their own seal, and I will show you that under number 6. The governor of this state shall make use of his private seal until a state seal shall be provided. Now, did they know who was going to be governor of Illinois? Of course not. But there was automatic presumption that they would have what? A private seal. So, when we create our seal for our own house, what we're doing is we're reestablishing that seal, that thing that everybody used to have and everybody used on a regular basis to seal their documents. And when you seal a document with a seal, it becomes more than just a contract. It actually becomes what's called a covenant. And there is a common law action called an action of covenant, in which if someone violates a covenant, you can bring an action called covenant. It's not used much anymore because none of these attorneys and the whole entire system has now gotten so far away from common law that it's all Roman civil law or law merchant system, which is predicated upon what the government allows you to have, basically privileges. Because there's a huge difference between unalienable rights under natural and common law and civil rights, which are something that is granted by government to infants or those who are literally property of the corporate state. So with the seal, you sign and seal the Vocational Science Freedom Doc Set. And after you do your seal notice, your declaration, establishment, publication, file, seal, in that document, it states that without that seal and your signature on a document, you cannot verify, meaning you, the sovereign, cannot verify that that document or that thing was not done under protest, duress, or with your full knowledge, meaning that it would violate the aspect of meeting of the minds of it being a lawful contract. So what it does is it throws a shadow of doubt on anything that you've ever done up to that point. Now, does it necessarily automatically negate it or reverse it? No. But the rest of the status docs do that. They do remove you from all of the rest of the contracts that you would have had with the corporate state. And that gets down into this document, which we'll get to in a second. Then after that, after you get your seal done and get your seal, and all of these documents basically get filed at the same time, but they get filed in this order: 1, 2, 3, 4, 5, 6, 7, 8, 9, and then 10, and then 11, 12 if you end up having a court situation, which I'll get to in a minute. So then you do the judicial coroner appointment, which appoints your judicial coroner to your house. Now, there are no longer any more judicial coroners from the standpoint of what that office used to hold as far as a power was concerned. Every coroner used to be a judicial coroner, meaning that you could go to a coroner and do what was called an inquest, also known as an inquisition. Don't confuse that with the Spanish Inquisition, but anyway, the purpose of an inquest is to determine on the court record something, and matters of life and limb, meaning that you've come of full age and that you are suing out livery of your estate, is a matter of life and limb, because your life depends on your estate, because part of your estate is your body. So, because you own your body, and because you own everything else that you have, then you must claim that back. And to reiterate, and the definition of an estate in its substantive definition is everything that a man or woman owns in law. That is your estate, all of it. And what people used to have to do in English jurisprudence, the Court of Wards and Liveries ran from about the early 1500s to about I think it was actually 1664, I believe, when they changed the Court of Wards and Liveries and then turned it into just the Court of Wards, which was then surprisingly run by the East India Trading Company. But I won't go down that rabbit hole at the moment. We'll leave that there. So what did this court do? What it did was is that when a ward had come of full age, which was not a number, but simply a state of mind, meaning that they could handle their own affairs, what the ward would do would be to sue the guardian for their estate, right? And this went on for 100 years. And then they ended up burning London to the ground, meaning the Luciferian fools that think they wish to own everything on this entire planet and everyone in it. They burned London to the ground on purpose, and then they instigated what was called the Sesterkevai Act, which then stated that, well, if we don't know you're living or dead, then your estate is automatically administered by the Bar Association. Well, isn't that convenient? Now, it doesn't actually state that. I'm stating that from a standpoint that it's what it ended up doing. It doesn't actually state it exactly like that in the Sesterkevai Act, but if you go read it, which you can find on the English governmental website, go read the Sesterkevai Act, and it's very interesting because it says that they have to try to locate and determine whether you're living or dead, which of course they never do. They just automatically go with the presumption that you're dead and that you haven't claimed your estate. And so then therefore they continue, the attorneys then continue to administer your estate through your entire life. And so it's important and necessary to sue out your livery. And in order to sue out your livery, the first thing you have to do is you have to appoint a judicial coroner, because you have to have a coroner in order to hold your court of record to do the inquest. Then you do your coroner proof of life and proof of age inquest, which proves on the public record that you're found to be living, that you've come of full age, and that you're competent to handle your own affairs. You convene 12 other people, 12 other sovereign Americans, and have them sign it with your judicial coroner present, and then that takes care of that situation, and then these two documents go together with the rest of the doc set to get filed onto the public record, proving that you have done this. People have come to me and said, well, how can you do that? You can't just create a court out of nowhere. Yes, you can. Why? Because you're sovereign. The sovereign can hold his court, or her court, wherever they bloody well feel like. I once read a very enlightening treatise on process. I don't recall the exact name of the treatise, but in that treatise regarding process, it talked about holding courts. It talked about suing out writs. And there was a story in there about a man, and this was like in the mid 1800s during the westward expansion of America. And there was a man who held court in a hotel room. Was that lawful? The answer is yes. So you can hold your court wherever you want to. You can hold it in the middle of the woods if you feel like it. It's entirely up to you. So you get those two done. And the next one is the execution of will, declaration, and claim of title. This is the BC claim. This is when you go and get your birth certificate authenticated, not apostilled or apostilled, depending on how you want to pronounce that word. You do not get an apostille to it. You get it authenticated, because there's a huge difference between the definition of the term apostille and authentication. And so you get it authenticated on the state level, and then it comes back to you, and then you send it off to the feds. They authenticate it at the Secretary of State level, and then it comes back to you with this nice piece of paper on it with the Secretary of State's seal on it, along with some very interesting law in the lower left-hand corner, which if you look up will tell you that this document is now as good as the original. Why do we do this? Well, where is your original birth certificate being warehoused? It's being warehoused at the DTCC. The DTCC is the Depository Trust Company and Clearinghouse at 31 Water Street, New York, New York, also known as the Tower of Power, which is literally above the door. That's where your original birth certificate is sitting. And I have heard stories, even though I have not taken the time to track them all down as far as being able to possibly do the process, even if it is possible anymore, I don't know, to actually get the original birth certificate back. And when they looked at the original birth certificate and they got it back, on the back side of it, there were routing numbers, because technically they consider and see the birth certificates as a check. Why do I know this? Because years and years and years and years ago, there were various different people that were trying to use the birth certificate to cash things out with. And every single time that they tried to do it in some way, shape, or form, whether it be a corporation or whether it was the corporate state, they would return the birth certificate and say, "We are returning your check." Every single time they called it a check. And that happened at least 4 or 5 times. And so we said, okay, fine, it's a check. It's also a warehouse receipt. But so what we do is we write a very, very specifically worded endorsement on the backside of the BC, and then connect and attach this birth certificate claim to it, and then record it onto the public record so that the whole world knows that we have claimed everything of that check and that we have deposited it with our house, and that all assets must now be reallocated to the executor, or the executrix, as the case may be. Then move on to the rescission of power of attorney. The reason you have to rescind all power of attorney is because this is how they create bonds on you. Every single court case is bonded, even a traffic case. We have process, and we can teach you how to acquire the bonding information. The people that have done this, when they get it back, all of the bonding information all shows that they created the bonds through a power of attorney. Why? Because you're sitting here as an infant and they're administering your estate. So what are they doing? They're continuing to put more and more bonds on your estate so they can create more and more of their filthy fiat currency. If you get rid of this problem, meaning destroy this system, the whole entire fiat currency system would collapse. Even if you didn't get rid of the Federal Reserve would go bye-bye if we all ended this process of bondage and unlawful administration of our estates, which is, of course, probate fraud. So that's the reason why I got to do the rescission of power of attorney. Then the next one is the executor or executrix appointment. This one alters based on if you're married or not. If you are married and you're a woman coming under a man's house, then the man becomes your executor so that he can protect you under his law. If you are a single woman or a single man, then you become your own executor. So that's why that document is important, so that you are the executor of your estate. And there's a huge difference between the word executor and the word administrator, which is posted in the link of which I put here. You can just go look it up and read directly from, I pulled both definitions directly from Bouvier's Law Dictionary, the 1856 edition, and they are a fascinating read to understand the difference. But I won't get into that right now. You can go read it for yourself. Number 7 is the fee schedule. This is something that people have been doing for years. And when somebody came to me and said, well, do you have a fee schedule? I said, and this was probably upwards of almost 20 years ago now. I said, yes, I can create one. And then it became a part of the doc set. And what the fee schedule does basically says, look, anyone who attempts or wishes to administer or attempt to administer this estate, basically in violation of the next document and against the will of the executor of the estate, there are fees that apply if you do that. Now, is this lawful? Yes, it is. Why? It's the same thing as walking into a restaurant and giving an order. The waitress comes up and says, "May I take your order?" You are ordering them to do something in a common law jurisdiction. If you order a man or a woman to do something in a common law jurisdiction, then they have the right to present you with a bill, which is, of course, what they do after you get done eating. You say, "Bill, please," right? And because of that, anyone who administers your estate in a common law jurisdiction, after you've claimed it, then owes you a fee for that use, because you have posted your fees and you have made them public, which then automatically enters them into a contract and enters them into this contract, this specific contract, because of the way it's written. And this, the fee schedule and this next document, which I'll speak about in a minute, both of these documents are performance contracts. You can create a contract in a way which, if someone else wishes to perform an action, they bind themselves then to the contract. Good example, you see this all the time. Go read a user-end license agreement for a piece of software. If you read it you will find that there are all kinds of things that you agree to simply by clicking yes and by using the program. That's called a performance contract. You use it, you're bound. Same thing applies here. We're just reverse engineering what the attorney has been doing to us for, well, a couple thousand years. Saying if you bind yourself to it, you owe us. Now, this document, which we affectionately call the kill warrant, or KW even for shorter, it was originally created as a single page document. And what it did was it removed the capacity of the court to administer the estate on behalf of the heir of that estate. And it worked the first time we did it. And it's also worked ever since from anyone that bothers to actually read it. Now, there are a lot of attorneys that won't, and judges, that won't read these documents. I don't care if they read them or not. It's absolutely irrelevant. Once they're served, they're served. That's it. And you process serve, and after you're done with all the documents, then you process serve them up till this one. You don't process serve these two. These two things will be something that you file into court, which I'll get to in a minute. But after you process serve the entire doc set, they're served. They have notice. And if they perform, then they are bound. And the enforcement side of binding in the contract, and if they violate the contract, is binding arbitration, which takes the whole entire process out of their filthy Roman civil law merchant system and places it into common law arbitration. There's nothing they can do about that because arbitration predates Roman civil law. In fact, the first, they were called praetors, basically judges in ancient Rome. They didn't judge anything. All they were arbitrators. And it was always the plaintiff that enforced the judgment or award. It wasn't the state itself. It was always the plaintiff. Because, of course, the plaintiff brings the sword and the sheriff brings the shield. That's why the symbol of a sheriff is a shield, not a gun or a sword or a tank. So there's a lot more that deals with this document. I'll just, if you want it, then we are happy to provide you at the Vocational Science of Freedom with the entire status doc set for the amounts stated in the price sheet, which is in the megalink. Then 9, the Declaration Oath of Citizenship. This is important because you have to correct your status as to being a citizen of the United States, of course, which you are not, except by your own ignorance, and perhaps by certain contracts which you might not have known existed or that you entered yourself into unknowingly and without your full knowledge. And that also gets corrected in the KW. All of those contracts, we specifically state in the KW on the public record that you do not consent to any contract which alters or violates or is in opposition to anything that is stated herein. So the KW supersedes anything else that might be out there, could have been out there. And coupled with the revocation of power of attorney and all the other docs already stated, that pretty much takes care of that problem. And then you declare that you are what you are, which is, of course, what you're supposed to be doing. I see a lot of people attempting to state what they're not in documents. They'll say things like, I am not this, I am not that, I am not. Well, okay, prove to me you're not a pink elephant. You can't prove a negative. You have to state what you are, not what you're not. And that's what this document does. It states what you are. That you're sovereign, that you're one of the people, that you're a de jure state citizen, that you're a free man, that you're a free inhabitant, all these various different terms. And we couple these various different terms with every single place in law, in American jurisprudence, of which they have been written down. Everything from the Northwest Ordinance to various different state constitutions to the federal constitution, the Declaration of Independence, the Magna Carta, and so on and so forth, and yada yada. And I think there's upwards of 22 various different things of which we state in there on the public record to correct any presumptions to the contrary. And then the Ordinance of the Estate is a very simple document where you take all of the public record numbers of all of these previous documents and place it into the Ordinance of the Estate, and then it's basically a one-page document, and file that on the public record so that if you ever come across a situation where you don't necessarily want to have to spend the money to serve all of this on someone, say a corporation or a debt collector or whatnot, you simply just mail them the Ordinance of the Estate and say, you now have to take your due diligence and go look up all these things, go look up all these public record numbers as to what they state, because you now have noticed that they exist. The definition of a notice is, the importance of a notice is that when you notice someone of something, you're telling them, be aware of this, take heed, do your due diligence, because it affects you. And it also is interesting in the definition of notice that it states that a notice is something of which both parties have an interest in. And once both parties have an interest in something, then you have to notice them, the fact that hey, your interest might be changing here, or hey, you'd better be aware of what is going on here because it's going to affect you. And if you do not pay attention to it, well, not my fault, not my problem. So, and then the special master appointment is if you have an issue in court and you need to appoint a special master over your court. This is a good thing to use if you ever get into a situation where you find yourself being potted and someone else needs to come in and sue out a habeas corpus. A special master can do that. I won't get into that too much. You can look up in the Federal Rules of Civil Procedure, if you wish to, which are not all that long. Go find and read the powers of a special master. It is right in the Federal Rules of Civil Procedure. So it's not like they don't know this position exists. And yes, you can appoint a special master to your own court of record in any court you want to. County, state, federal, doesn't matter. Marshal appointment, this is the last document. These two go together when you're filing them into a specific court case, not just on the public record. Even though there's no problem with filing them on the public record, they have court headings on them which are specific to, which you would want to put your own court case into. So they're specific to the case and not a general document. And the marshal appointment basically says, look, these are my marshals. They have the right to process, serve any documents from this court, and they have the right to enforce the judgments of this court. So that's the entire vocational science freedom status doc set in a very, very short nutshell. Now, I needed to state all that because of what I'm going to now talk about, which is what should you do after you remove yourself from the system. One, you can never go back and enter back into contract with them, meaning there's no more filing of IRS paperwork. There's no more using the Social Security number to open up a bank account. The reason why all of this has to happen is because your body is not in commerce. The government is not your pimp. They do not own your body, unless, of course, you let them. But after you do the status docs, you're declaring once and for all and forever that they do not own, may not administer, and if they do, they're going to be bound by the contracts as previously stated. And that the reason why we have to do it is to take our own bodies out of commerce. We are considered a human resource. You hear that term all the time, but people don't, or tend not to, cringe when they hear it, as they should. The term human resource is literally calling you a slave. And maybe I would go so far as to say that it's diminishing your existence even below that of a slave. I mean, at least a slave still has its humanity to an extent. They don't have their freedom. But when you're called a resource, you're denied your humanity. And I fail to understand why people don't cringe at that term. Point being, your body is not in commerce. This whole entire Roman civil law merchant system is set up to have bodies as resources in commerce. And so that the attorney can administer your entire estate for the rest of your life until you're dead. So we need to remove ourselves from commerce in that way. So what do? Okay, there's various different things that you can do, and all of these things are entirely up to you, whether you wish to do them or not. And I'm totally willing to help anyone who wishes to do them. There's no charge for these various other different things, aside from the fact that if you want me to fill out your SS4 form, which is an IRS form, which tells the IRS that you are now the executor or the executrix of this particular estate, and that you require an estate EIN number. So that's the number that then you would then use to open a bank account and transfer all of your assets into, that you had under your original Social Security number, and then that makes you the executor, or again, executrix as the case may be, over those assets. Why would you do that? It's because you are settling the estate. What does a proper executor do? They settle the estate. They collect all the assets, put them in one place, then say, yes, now we have all these assets. This is what it is. And now I'm going to distribute those assets to the lawful heir, or heirs if it were someone who had multiple children, and you were doing this from a standpoint of having to be the executor over someone's estate who had actually passed on, which I've done before. I do it for my father's estate. So, and all of these things connected and made perfect sense when I did that. I'm like, oh, yep, well, here you go. Yep. And now the executor. And when you walk into a bank and do this, they don't even hesitate. They're like, okay, yep, you're executor. Okay. And you bring your executor appointment along with you, put it down, put it in. Yep. Okay. You're the executor. Fine. Done. Yep. And you can open up a bank account in it. And they really don't question it. As long as you give them some damn number from the IRS, they don't care. They don't know what you're doing anyway. They really don't have this level of knowledge that you learn here to do that. And yeah, the aspect of employment. Okay, so let's go there for a second. So the aspect of employment, when you go and to a corporation, what they're going to ask you for is what's your social security number? What's the withholding tax? And you say, no, I have a 32 EIN estate and I'm the executor of it. And actually, you wouldn't even have to explain it to them. Just put the 32 EIN in the place of the damn social security number, and then state that and then state to the employer that there can be no withholding because of the nature of this EIN. And they really can't question it. And if they don't want to hire you, well, then of course that's their prerogative. But so that's one of the options. Another thing you can do is that, yes, you can set up a business. You can have a non-for-profit business. Exactly, Shift. You can go that route. You can have a non-for-profit business, and you don't have to convert it because the business has its own number. It's its own entity. You are not that business. It is its own entity thing in the law merchant system, and it does its own stuff and has its own deal. And yeah, you can have a 508 or a 501c3 or you can set up a C corporation, whatever, doesn't matter. But that thing, whatever you're doing, that's the thing that's in commerce. It's not you. And that's the point, is that you can operate completely free and clear of your own estate having anything to do with being sucked into this system. Right? That's the problem. It's the destruction or abrogation or diminishment of rights that you end up creating when you're working in this Roman civil law merchant system as your body being in commerce. If you have a conduit entity, then your body's not in commerce. The entity is, right? So you can do it that way. You can also set up a common law trust. Now, there's a gentleman that I know who is extremely intelligent and has more knowledge about trust than I do by far, and because he studied it and focused on it basically his whole life. And it's a very interesting situation that he's in, because he can go to the IRS and get a trust number set up for a trust. And then what he does is he uses Texas law, which they just changed not all that long ago, where under Texas trust law, they brought back forward and basically reestablished, if you will. Well, reestablished is not exactly the right term. There is a technical term for it, but it escapes me at the moment. That basically they re-recognize the common law under this trust law, the way that Texas rewrote its trust law. When he writes the trusts in that way with Texas, what he does is that he's the one that goes and gets the EIN number for the trust, sets it up under common law. He remains as a special protector trustee in case they might come against you or whatnot, that he'll actually go and defend you in court. And his trusts have been tried on the federal level, and they cannot be broken at all. And so what he does, so that it's not what's called I think it's called self-executing trust, wherein you never want to make a trust where you set the trust up and you become the trustee, so everything comes to you, trusting the beneficiary. That would be self-executing trust. Those are able to be broken in half quite easily, actually. But the way that he does it is not. The way he does it is that he sets up the trust, and then you put the assets in, and then he transfers the trusteeship in the first minute of the trust to you. And so that way it's not a self-executing trust. And again, the reason why he can do this is because he never entered the system. When they told him at age 18 that he had to go get a social security number and that he had to pay taxes, he said no, and I'm not doing that, and I never will do that. He never entered into that first contract. He never ever signed a first IRS quote unquote tax form. And the IRS is well aware of this. And so he has the capacity to get these numbers in a way that I don't really know how anybody else could, oddly. And he's the gentleman that I send people to if indeed they feel more comfortable setting up a common law trust, of which then all of their assets are in trust and cannot be touched by the corporate state. So that's the way that he does it. If anybody wants to go down that route after they've gotten their doc set done, feel free to contact me, DM me in Gilded, or send me an email to vsof@protonmail.com. And then the other way to do it is what I do, which is simply only transact things in gold and silver and not have any bank accounts. And if I do need to go get cash, I'll cash out a little silver and go do that. But the vast majority of things that I have now do not require basically any digital transaction. I do still have people kind of helping me with digital transactions regarding the VSOF simply because it's sometimes easier for people to use PayPal. And so I have people and friends that are welcome to, help me be able to use their PayPal accounts for that. Yeah, the issue about the death certificate for the EIN, this has happened a few times. When you try to do the EIN, they'll say, "Well, we need a death certificate to say that the man or woman is dead." No, you don't, because you have this labeled as a decedent in your master file. Now, what you can do to get around that, if you really have to or really wish to, there's a form that you can demand your entire IRS master file from the IRS. And you can demand it in a form that is understandable to you. Meaning you can demand that the IRS send you your master file in a way that doesn't have any numbers or codes or abbreviations or acronyms or whatever else, and that they have to tell you what these things mean because it's literally written into the IRS code. If you get your IRS master file, it'll show you as being labeled as a decedent. And you can just turn around and tell the IRS, "Look, you've already got me labeled as a decedent. There's no need for a death certificate." End of story. So give me the EIN. Okay, and next part of that, years ago, I filled out my name as it appears on the birth certificate on the Secretary of Business website, Secretary of State business website. Well, yeah, you're putting it as a private estate, but at the same time, they're going to see that again as being connected with your estate, and that's kind of like almost putting your estate right back in commerce again. I wouldn't necessarily do that unless I went through every single kind of document as to what that process would be. I can almost guarantee you that somewhere in there, there's a hook that takes you back in. So I wouldn't see that as a solution. Only the solution from the standpoint of getting the EIN and having the IRS recognize it, I would see as being legitimate and part of a good solution for that. John, I don't know what a W8BEN is, so I can't answer that question. And then next, common law trusts do work. Yeah, common law trusts do work. I mean, if you think about it, all the constitutions are common law trusts. That's what they are. How do you know that? Because they have an executor, right? The chief executive office, right? That's what the federal government is. It's a trust. And all of the constitutions, both state and federal, they're all contracts that are owed to us as we the people. No, you don't have to create a bank account to claim your estate. No. You're creating your estate and you're rebutting all the presumptions on the public record, which is the important thing. And you're doing your proof of life and proof of age inquest, which is also the important thing. And you're placing that onto the public record because the jury that does your proof of life, proof of age inquest, does what is called a general verdict. Now, in case no one studied the definition or gone and looked up the definition of the word verdict, there are many, many, many different kinds of verdicts. And there are specifically 3 different kinds of verdicts that a jury can bring. And You want them to render a general verdict. A general verdict is a verdict in which the jury finds both the facts and the law. And because of that, they can determine that your law that you've written down in your proof of life and proof of age inquest is lawful. And once a petite jury does that under a general verdict, it is law. Full stop. So, is there any other way to receive payments for our estate? You're not receiving payments from your estate. You're claiming the whole thing. And as far as what might be out there, as far as people talking, or a lot of this talk as of late in the last few years, or maybe even last decade, about there somehow being some, the minor accounts, or that there's some account at the U.S. Treasury, like U.S. Treasury accounts or something. I don't find any validity in that because there's nothing at the U.S. Treasury. Can you open a U.S. a Treasury Direct account? Sure you can, but that's for like buying bonds and things. It has nothing to do with the idea that there's already some sort of Treasury Direct account that you can tap in on. That's nonsense. I have not found any valid proof of any of that shit at all, ever. Now, what I have found proof of, and what I do know exists, is that there is a bond that is connected to your birth certificate. And the bond connected to your birth certificate is being held at Fidelity. That you can have done through a Bloomberg audit, which we have a company that will do an audit on your birth certificate, and they'll send you back the information as to how much that bond is on the BC and what its CUSIP number is. And then what we're planning on doing is that we're planning on taking the entire status doc set and going to Fidelity and opening up and saying, look, here, this is the information. You're holding this bond. This bond is in this estate name. These are all the documents that are required in order to prove that I have claimed the estate. Now I need you to cash out that bond and give it to me. That would be the only possible way of there being, that I know of, anything sitting out there, that I know is sitting out there, that could possibly be quote unquote cashed in. Now, technically, I don't think it would be, in the way that bonds work, I don't necessarily know that you would cash it in per se. I think you would just cancel the damn thing. Now, if you cancel that bond on the Fidelity side, then you're no longer in bondage, because from my understanding and my research, from what I found, is that that Fidelity bond is the thing that keeps us all under the bus. And there is another place that there may be assets. There may be assets at the DTCC, being held at the DTCC. That's the only other place. And it's not conjecture. It's a very well put together aspect of a theory that it's most likely at the DTCC, simply because of the way that everything has read and that we've found. Particularly, there was a part of, was the District of Columbia Code that I went through a few years back, and I spent a month and a half going through the entire District of Columbia Code looking for one word every single time that it used the word estate. And it happened to have 1,562 entries, and I went through every single one of them until I found what I was looking for. And what it turned out was that trust companies are what is acting as the guardian. What the trust companies do is they hand off the administration of the estate to the Bar Association. So who is the guardian? That's the DTCC. Trust companies. Who's the guardian? Fidelity. It's a trust company. Okay? They hand it off to the Bar Association to administer it. Who, of course, created all these huge trust companies? Attorneys. So, it's just a little vicious circle, right? But anyway, so at some point, we're going to put together the package to send off to the DTCC and to send off to Fidelity. And I would also eventually send off a package, and you can do this on your own if you wish. You can serve the KW and any other part of the status docs that you wish to on the credit reporting agencies. There's 3 major credit reporting agencies, and I believe it's Equifax, Empyrean, and TransUnion. And then you could definitely serve all 3 credit agencies, because if you serve the credit agencies and they actually read the documents, they actually read the KW, they are forced to, as by contract, they are forced to remove all records that they hold give you the records, meaning the originals, and they're also required to give you a full accounting of everything. If they did what they were supposed to do from the credit reporting agencies, honestly, what you would get would be like probably 5 or 6, or well, depending how old you are, bankers' boxes full of paperwork showing you every bloody transaction that your social security number has ever gone through. And then they're supposed to also uh, give you livery of anything that they're holding. And I'm sure their credit reporting agencies aren't holding anything. However, they do have a tremendous amount of accounting, of which they, again, have to, under that contract, produce to you because you're the executor. And again, in being the executor of someone's estate before, when you walk into places and you say, I'm the executor of such and such estate, I'm here to settle the estate, and I need all accounting of it, and you act like you know what the hell you're doing, they will give you everything. I never, ever, ever once had a problem with that. And I had to deal with multiple different corporations, different banks, different brokers. Just walk in. I'm the executor of the estate. I'm settling the estate. Here's the information. Bam. They'd have everything to you in a matter of like minutes. They'd be like, if you'd wait right here, sir, we'll have this all together to you in 15 minutes. Thank you. Would you like some coffee, sir? Would you like a donut? In 15 minutes, they'd bring everything out and off you go. After you eat your donut, that's it. It's not rocket science, man. They understand the term executor, and it's it's the strongest position you can have other than heir. Well, actually, let me rephrase that. There's three major positions, the three most important positions that you ever want to talk about or even bring up in regards to all of this. Whether and some of these terms are aspects of Roman civil law, some of them are terms of the common law. And to make a point of that, the term executor is a barbarism to the Roman civil law. Now, what's a barbarism? A barbarism is any word that they don't understand. Meaning, somebody goes bar, 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 bar. That's where the term actually came from. That's what the Romans came up with that term, in referring to the Germans as, barber, because they go bar, 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 bar. Anyway, interesting etymological piece of history there. But anyway, so the term executor is a barbarism to Roman civil law. They can't deal with it. So when the executor shows up, bam, all Roman civil law is out the damn window. Sorry, we don't do that here. We're talking in this language, and you have to obey because it's the higher law. Okay, so the three are executor, heir, and grantor. That's the three most powerful positions. Now, if you go read the Powers of Appointment Act, I believe it was 1951, but I believe there was one before that, so you probably want to read both of them. I read them a long time ago, so I can't exactly quote them, and they're not all that long. But in the Power of Appointment Act, the grantor has all of the power to appoint whoever they want to. So the grantor basically has the capacity to appoint the executor. Now, you, being the only entity that it owns your own estate, you're automatically the grantor of your estate. Now, I've had some people argue, well, your mother and your father is the grantor of the estate. Well, no, not if you come of full age. They might have been your guardian for a while, but no, they're not the grantor. You'd be the grantor. So when you take the position of grantor, executor, and heir, those are three terms that the attorney cannot deal with at all. Honestly, at all. I mean, there was one time in court, this was just for a traffic ticket. The judge asked me, he said, state your name for the record. And I said, I, First Middle, come before this court as having been found to be living, and as the sole lawful executor of First Middle Last res defendant estate. Is there any objection to what I just stated? The judge looked like crazy, like he was taken aback, and he like slowly started to pick up my file that was sitting next to him, and slowly started to turn in his chair. It started like literally stumbling over his words. He's like, the court's gonna take a recess, and I said, I do not consent to this unlawful proceeding. And the attorney piped up and said, Your Honor, that's not his name. His name is First Middle Last. And I said, objection. I said, my name is First Middle. I am the house of Last. And then the judge tried to pull this. Well, so you're saying you don't know your own name? And then he tried to pull the competency route. And well, actually, the stupid district attorney tried it first, and they said, "Well, Your Honor, we come, we come," and they because the district attorney was trying to save the judge's ass from being in a position where the second that you say that, they become an executor. They become an executor de centur. Now, what I really should have done is should have let him take the goddamn recess, gone back into his chambers, taken his name off of the fucking account, and then when he came back out, then demanded full accounting and said, "You're no longer the administrator. I demand, I demand a livery of season or sorry, I demand livery. Livery of season is technically with land. I demand livery and a full accounting, and I demand that you provide for it." And he should have given it. Then they have to give it up because, of course, they're the ones that are holding it. I'll just leave the rest of that story aside. But the point is that the second that you say that you're a sole lawful executor, that's it. He's fuckled. There's nothing they can do after that, for the exception of the fact of just continuing and proceeding unlawfully, which I'm not saying they don't do, but they're well aware of the fact that it's a probate court. All traffic courts are probate courts. In fact, everything you're practically doing in any court is a probate court. They're running everything systematically through many, many, many different jurisdictions all at once. They're running it through maritime admiralty. They're running it through the law merchant. They're running it through Roman civil law. They're running it through equity, and they're running it through probate. All of it. All of it. And technically, in a weird way, they're kind of running it through military tribunals as well, because you got the yellow French flag up there, and you're considered an enemy combatant under the Trading with the Enemy Act. That then expanded out to everybody under the treasonous bastard Roosevelt. So anyway, does anybody have any questions? And you're free to unmute yourself if you wish.
Do you have a sample of the self-certifying letter?
An example of the self-certifying. You mean the verbiage that goes into it? Yeah, I do.
Is that just?
I do. I do.
Just like Title 28, 1746.
That sounds right.
Is that the thing?
That sounds right. I mean, don't hold me to that, but that does sound right because the gentleman that taught me about that, I have some of his documents and at the top he has it written out. But yeah, I believe that again, don't hold me to that, but I believe that is the code that you can self-certify. And it basically all you have to, okay, I think I do remember it now. What you state at the top is that you say, "I swear under penalty of perjury under the laws of the United States of America that this is a true and correct copy of an original copy that I have in my possession." Period. That's it. Yeah, that's how, and then you sign it. That's exactly how you're supposed to say that.
Okay. Yeah, Title 28, 1746, Section 1.
Okay.
Right.
And always remember to state that I swear under penalty of perjury under the laws of the United States of America. Because if you don't put under the laws of the United States of America and you just put I swear under penalty of perjury, then technically you're under the United States, not under the United States of America, which is the proper republic.
Yeah, that would be, I think Section 2 is the United States.
Yeah, that's the part of it.
Or vice versa. I don't remember.
Yeah, I don't remember either. I think Section 2 might be it. Yeah, you're right. Yeah, so it's Section 2 because it does state that it states that if you state under the laws of the United States of America, it is without the United States or something to that extent, as if I recall.
Yeah. Okay, I thought that's what it was. I just wanted to get your thoughts on it. So.
Yeah, no, that's it. Yeah, I swear under penalty of perjury under the laws of the United States of America that this is a true and correct copy of this is a true and correct copy of an original that I hold in my possession. Yeah, period. Yeah.
Okay. All right. Thanks.
Or is held by the house of, Robinson or whatever. However you want to finish that, it's fine. Either way.
Okay.
Yep. Anybody else got any questions for this evening? Okay, cool. Well then, I thank everyone for showing up, and I hope you all had a wonderful time. Hope you all stay well and stay sovereign, and I will see you guys this coming Saturday.